Welcome. Welcome to A Taste of Justice. I'm Professor Angela May Kupenda. All interpretations and views expressed here are my own for identification purposes only. I'm a professor of law at Mississippi College School of Law. Okay, let's get to it. This clip is for the Civil Rights Lawsuits course I am teaching to give my students a brief introduction and a review, and to give all of us a taste of justice as we try to understand the civil rights cases that are ongoing and that are likely to come under what's called Section 1983. So we've been talking about who can be sued, who is a defendant under 1983. And the question for today is, can cities or counties or municipalities be sued under Section 1983? Now, for simplicity, I'm just going to say a city, but that refers to a county, a municipality, or what have you, a subsection of a state. We know states cannot be sued as states under 1983. And earlier in 1961, the court had said cities could not be sued. But we're going to look at the court's change of that ruling to a degree, and the court held that cities can be sued. The case was Monell versus Department of Social Services of the City of New York, and it was in 1968. Now, in that city, at a certain stage of their pregnancy, pregnant women were required to go to the house without pay to await the delivery of their child. It didn't matter if the woman was able to work. It didn't matter if she needed to work for her income under state law, under the city, under the city ordinance, the city law. These workers were required to go home and without pay. So they brought suit. And they said, this is unconstitutional. And the court agreed that it was unconstitutional, that they could not be required to go home and not work when they were medically able and without pay. But even though the court said that it was unconstitutional, the women did not receive any back pay. So in a subsequent case before the court, they sued and said they were entitled to back pay. Now, if they had sued just the individual officers would have likely been entitled to qualified immunity because the law was probably not clearly established at that time when they were sent home without pay. So the women brought suit, suing the city, the Department of Social Services of the City of New York. And the court said a city could be sued. And then subsequently, after the court's ruling, the women received a settlement for all of the back pay they had been missing. Now, how did the court change? The court said, well, we got it wrong back in 1961 when we said cities could not be sued. But the court also said it makes sense. Who is the city? The court said all of the taxpayers, that's the city. And the court used a doctrine called loss spreading. So instead of having this group of women suffering because of the unconstitutional deprivation, the deprivation of their constitutional rights, the court said instead of having a few women to suffer, we will spread the loss among the many taxpayers of the city. So the court said loss spreading spreads the loss among the city so that a few do not suffer. So therefore, the court held that cities could be sued as defendants under 1983. Well, you know the court didn't leave it there. The court said, however, and the court gave a big however. The court said that respondeat superior does not apply, which means every time a city employee does something wrong, that does not mean the city is liable. The court said for the city to be liable, the plaintiff must show something more. For example, the plaintiff can show that there is a custom, a policy, some rule of the city, in writing is better, and therefore this policy of the city is what caused the deprivation. But what if a plaintiff does not have that written policy? Is there still a way for a plaintiff to prevail against a city? The court said, well, if there is a decision by a final policymaker of the city, you're like, what's that? Well, there's one case that's really interesting. This case is called Pembar versus City of Cincinnati. Now, Dr. Pembar had been accused of Medicaid fraud. And so the police were coming to Dr. Pembar's medical office to serve subpoenas on some of his employees. When Dr. Pembar heard them out there trying to get in, he said, you're not coming in my medical clinic. And he actually barricaded the door. So when the county officers were trying to get in, they couldn't get in because Dr. Pembar barricaded the door. So it was the deputies called their superior, and their superior told them to call the county prosecutor, and the county prosecutor said, you go in there and you get him. And so they went and got an axe and they chopped down the door and went in and got him. Now, the interesting thing is, in his criminal case, Dr. Pembar was acquitted. He was found not guilty of the Medicaid fraud. So now, Dr. Pembar, who wouldn't let the police in, he's now suing the county, because these were all county officers. He's suing the county, rather, for violation of his rights under 1983 for what they did. And it turns on whether or not a decision was made by a final policymaker. There's no written policy or what have you. There was a single telephone call with instructions. And the Supreme Court said, that's good enough. And therefore, Dr. Pembar was able to recover. Now, a single phone call, in other situations, the courts have not ruled the same way. But in that case, it did indeed work. Let me give you another interesting one. You have this man who served on death row for 6 years, and he was innocent. He served for 6 years. Now, the county, before his trial, the county had evidence that demonstrated that he did not do it. But the evidence was withheld from the man's attorney and not given to them. So after he had served on death row for 6 years, all of this came out. After he got out of jail, he brought suit against the county. He said the county sheriff's office was the office that had unconstitutionally refused to give him the exculpatory evidence that if he had had access to it, he wouldn't have been on death row for 6 years, because this showed that someone else did it. Now, he said the county sheriff was the final policy maker for the county. Therefore, the county should be liable. And a jury brought back, I think this is the one where they brought back a huge millions of dollars verdict for him. Oh, I'm not confusing with the next one, but he had prevailed. But the county appealed and said, wait a minute, the county sheriff is not the final policymaker for the county. And the court agreed. The court looked at the state constitution, the state of Alabama's constitution. And the state constitution said that the county sheriff was an employee of the state, not of the county. So the court, the majority said the county sheriff is not the final policymaker, so the county is not liable, so you get no recovery for your time on death row. Now, of course, there's a dissent, but it was, they lost the vote. The dissent said, wait a minute, this county sheriff works for the county. This county sheriff, his salary is paid by the county. He is elected by the county. How then is he not the final policymaker of the county? But the majority in the court said he was not, because the Alabama Constitution said he was an officer of the state, not the county. So this cities can be liable, counties can be liable, but I told you there's a big however, and these cases illustrate that. Let me give you one more. The court says that a city can be liable, a city or other municipality or county can be liable for failure to adequately train its employees, right? A plaintiff, but in order to recover, even if they did not provide training, you have to show more. According to the court, you have to show that the city was deliberately indifferent to a high degree of risk. Not that they were negligent in not training, not adequately trained, but they were deliberately indifferent, that they made a conscious decision. I imagine you're going to see some of these claims with some of the cases that are going on right now. I can see an argument that a city or a county or other governmental body, not the state, but beneath the state, lower than the state, should be aware of training its officers in de-escalation, training its office in terms of working with individuals of different races than they are, and so forth. But here the court said you're going to have to show they were deliberately indifferent in their decision not to adequately train. Let me give you another one. A city can be liable for failure to adequately hire, but you have to show that the city was deliberately indifferent to a high degree of risk. So in this case that's mentioned, I cite these cases in the bottom in the notes. In this case, there was this officer, a sheriff, who hired his great-nephew. Now, he knew his great-nephew had some issues. I don't even think, if I recall correctly, he didn't even issue him a weapon because of these issues. So when they pulled over a motorist, the great nephew used excessive force and caused great injury to the motorist, and she filed suit. Is the county liable for failing to adequately hire? The court said no. They said he knew his great nephew had problems, but he didn't know he would do this, that this was a single hiring incident. It doesn't show that broad pattern of practice or custom of the sheriff's office making these hiring decisions without evaluating qualifications carefully. And since there was not this pattern, this broad custom, all the plaintiff was pointing to was this single incident, the court said that's not enough. So the bottom line is, number one, a municipality, a city, a county, what have you, can be sued under 1983. But there is a big however. Again, this is A Taste of Justice with Professor Angela May Kupenda. You know, I'm hoping that we achieve the goals and promises of the preamble, that we the people can establish justice. And I believe that one way of establishing justice is by our learning and having more enlightenment and discussion about the law. So subscribe and watch often, and check out the clips I have on the Constitution too. Okay, thank you and take care. See you next week.